And they say, but it says husband and wife, you know. And I said, well, unfortunately, New Mexico is community property, and you do have to probate it, even if you have a will, and etc.
So there's demarcation between joint tenancy and community
property.
Okay.
And then there's all other sorts of things you can do on your, for instance, your life insurance has the name beneficiary. That does not have to be probated. Any other accounts, such as bank accounts or those kinds of accounts that you specify on there payable on death, those do not have to be probated. There's a trust that do not have to be probated. A life estates on a property. If you have a property and you give someone a life estate, that does not have to be probated. There's a new kind of deed called a transfer on death deed that you can do. It's fairly new in New Mexico and not in every state, but you can leave. I could leave my property to my kids, for instance, but do a transfer on death deed. Nothing happens on that ownership, the title, until I die. And then automatically they present the death certificate and automatically the title is transferred to them.
Okay.
That's a fairly new process. There's some glitches with it as far as the title companies, but you know, there's still it's an avenue.
Since it's so new,
it's an avenue.
Hopefully
yes.
they'll iron those glitches
yes.
out fairly soon.
Well, for one of the problems with the title companies is that creditors have a year from the time you pass away to present a claim to your estate, and if you deed it over immediately upon your death, they can call it back. They have that right, but you know, so they don't issue like an insurance policy on title insurance till after that year is over, things like that. But other than that, that's a pretty good process. But most of the time when I do the presentations, people are more interested in wills. In wills,
and certainly we've probably got about another 8 minutes to talk, and that I was hoping would be the bulk of what you talk about. I see right there, who may make a will? Let's start with that.
Okay, you have to be 18 years of age or older and be of sound mind. And that can be defined by how, you know, interacting with a person and just asking them, do they know that they're making a will? Do they know what they own? And things like that. So people have to be aware of what they're doing in order for the will to be valid. You have to have 2 witnesses by 2 competent people.
And that's basically 2 other people who have read it and sign a witness line in front of a notary public,
well,
maybe?
actually, it is required to be in writing. And it's signed by the testator, who is the person making the will, and the 2 witnesses, who I'll have to sign in each other's presence. But New Mexico does not require that it be notarized.
It does not. That is very interesting.
No.
Oh, I see it right there on the bottom of your notes right there. Notarization is not required. But you do need 2 witnesses that sign.
I think, and most attorneys will do it because I think they want to avoid any problems in the future. You know, any perception that there might have been something, you know, that wasn't quite right, you know.
Hinky,
and to avoid any kind of,
yeah.
So it's a good idea to do it, but it's not required.
Okay.
Okay? And then, of course, based upon the will, the importance of the will is a couple of things. One is you name your personal representative. And that right there eliminates a lot of problems from the beginning. Because if you don't have a will, you have to go by the law of intestate succession and name the heirs in a certain priority.
So order. I have an older sister. Most likely, she would be the one appointed by probate.
Well, actually, you and your sister would have the same priority.
Oh, interesting. Because one's male, one's female. I'm getting ahead of this, and I need to keep quiet and let you go.
Well, no, and what happens in a lot of cases is that's where the first problem arises.
Oh, really?
Because if you don't have a named person in a will, then, like I said, you have to go by a certain order. The first priority is the spouse. The second priority is the children, but the children all have equal priority. If one of the children has died, then their children assume that right. So you get these families that are local families here that are 10, 13, 12 kids.
You got
and
three,
got
four,
lots.
three and a half generations
And
basically standing in front of you.
And they all have to consent
Okay.
to the person that's going to be appointed.
So I can see how that can get complicated.
And you shouldn't just name one person, you should name an alternate as well, because a lot of things happen. You know, maybe 20 years the will has been made and the person might be gone. Or
shipped out with the military, or you just and can't come
come into
to court.
Mm-hmm.
So okay.
So that's an important.
So let me ask a question, because I keep hearing people mention this. Something about filing your will with probate court?
No, you record your will at district court.
That's where you do it.
District court. And a lot of times that happens and they don't tell anyone. And in district court, what you're going to do is you're going to tell them who to turn that will over to when if someone has to present themselves, and they have to be on that form that you filled out when you recorded that will.
So they'll give you a form, you fill it out, and probably pay some small fee.
And they actually keep the will.
Oh, okay. Yeah, that makes sense.
And the will, that's important, because when you do probate, I have to see the original will. I cannot accept a copy. And that sometimes is a problem as well.
Yeah, but for obvious reasons,
Yeah,
you need to see the original, because some fudging can go on with copiers and the like. But okay, so we've talked about wills. What's the next thing?
Well, there's two ways you can do a probate. You can do it yourself, and it's called the pro se process, or you can do it through an attorney. And if you're going to do the pro se, which about 90% of my clients do, you can buy a packet at the Doñana County Clerk's office for $5. You can download them from the internet free from the Supreme Court website.
And they've got the web address up on the screen there.
And those are entirely free. The only problem with that is that they are in Word perfect, and you have to convert them. Why the Supreme Court?
Why they did that?
I don't know.
We don't know.
But if you'll call me, I have them on Word. Our IT has converted them.
Bring your jump drive.
And I can just email them. And they also have them all together. So at least in the packet, when you go, you say there's a packet for with a will, and there's a packet without a will. So you don't have to sort through which are the right forms. They're all together, and $5 it really just pays for the paper and all that. So that's what most people do. And when you file that, it's the only cost that there is involved is the $5 for the packet if you buy it, and $30 a filing fee, and that's all. There's no further cost.
Yeah, and there's not going to be any question about that will. You get that turned in, and it is solid, filed, and
if it's properly, witnessed, and it's the original will, there's no problem.
Great. Okay, about 2.5 minutes. We've got a few more slides to get through. Affidavit of surviving spouse.
Yeah, that's one way to get around a probate. If it can be used when a husband and wife lived in a homestead that was acquired during their marriage, and they don't have any other property. This is it, just a little home, and its assessed value is less than $100,000. That's becoming a problem.
That's becoming a problem.
And it's been more than 6 months since they died. They have to wait 6 months after the death. But it's a one form. They get it notarized. They record that with the county clerk. That together with the copy of their deed and the death certificate, and they're done.
Great.
Less than $15 to
awesome.
record. So then the other is an affidavit for collection of personal property. That is to be used when there is no real property and less than $30,000 in an estate. Say there are some bank accounts, etc., like that type of.
Maybe a used car, that kind of stuff.
Yeah, that's less than $30,000, but they have to wait 30 days from the death, and they present that to the bank. It's not part of my court. I have the forms, and I'm glad to give them to you, but it's between you and that person holding that personal property.
All right.
Okay. The banks are a little bit skittish about them, but it's perfectly legal, and sometimes I have to call them and show or send them the statute, and once they're informed, they usually go along with it.
All right. Well, we've only got a few seconds.